Good evening, everyone. My name is Yashodhara Barman Roy. I am a principal associate working with Hammurabi and Solomon. Today, we have a very engaging session with our senior partner, Mr. Jyoti Kumar Chaudhary, joined by our senior associate, Shubham sir, along with our friends from Nigeria, Mr. Adeola, Ms. Hassan, and Mrs. Deborah, who would be helping us navigate and understand the regulatory framework that works within India and Nigeria and how collaborative it would be for potential investors, how the regulatory framework works actually when we are doing business in India and Nigeria. To speak to speak about the relationship between India and Nigeria, a very common and yet a painful thread that joins the two wonderful countries is the struggle against the colonialism and the apartheid in the formative years after the independence of the two countries, and that has led to a very strong foundation of engagement inter say the two countries. Today we see India and Nigeria playing as important roles in the south south cooperation. We see them as notable voices and speakers and organizations in international multilateral forums of the United Nations, in G77 and NAM, where both these countries are continuously articulating the voice of a developing world in a coordinated but yet in an effective manner. It is very interesting to note that even before Nigeria became independent in 1960, India had established its diplomatic house in Lagos in 1958. The relationship spans from then. It does help that there is a large expatriate diaspora of India that continues to live in Nigeria, giving a way for that West African gateway and Indian collaboration to keep on strengthening and building over the course of time. A few insights into the different kind of bilateral trade economies that we do see today panning out are the regional integration through the African Continental Free Trade Area Agreement, which was entered between India and Nigeria in 2018. This aims to reduce the trade barriers across Africa and facilitates India's deeper engagement with African markets. Another very interesting point to note is that Nigeria happens to be India's biggest trader here in India, giving India a gateway into West Africa, whereas India continues to be the biggest investor and trader for Nigeria. This is a very significant step in India's stepping stone in becoming and continuing to be largest trading partner for Nigeria. The main gateway for India and Nigeria is also our energy business. India is the largest importer further of Nigerian petroleum products, which forms a major component of Nigeria's exports and meets India's rising energy demands. So these are some of the tidbits into understanding how the bilateral trade relations, which were forged so long ago, taken forward and promulgated under the vision of the late Sri Manmohan Singh in 2007, and how it has panned out today. We would now take our session forward in understanding where exactly the regulatory framework in India, if at all, plays a hindrance. If not, then how better it is for key investors to look at what are the key points that they should be aware of before investing in India. With that, I would open the floor up to different questions that we would be posing to both our speakers from India and Nigeria to have a better understanding of the regulatory framework and how the business works. On to you, Jyoti sir. If I may, I would like to ask you a first very important question that in the current circumstances of the regulatory framework of India, do you envisage that the legal and commercial trajectory of India and Nigeria as a strategic partner has been helping to continue to foster the bilateral investment and collaboration? Or do you see that India's present position continues to play a favorable jurisdiction for foreign investors? If not, then what exactly, where is India lacking even from a global regulatory standard where we could catch up?
Thank you, Yashodhara, for that really insightful question. I mean, and to answer that, let me give just a backdrop of this thing that India presents a compelling destination for foreign investment, no doubt about it, because and there are aspects to it. Like India is the fastest growing economy in the world. It's well noted, and it has the largest consumer base globally, given its population of 1.4 billion. So aside to that, the strategic policies that Indian government has put in place, for example, which has improved the business-friendly environment in India, and which has led to improved global ranking of India in ease of doing business index. So these are certain aspects which actually has gone to make India a favorable investment destination. Now, this fact would be evident from the India's position as 15th in FDI inflow. It is ranked 15th in the FDI inflow, and it globally ranks third in real estate investment. So these are just an evidentiary values that figures that I'm putting. Then India's aspiration to become world's largest manufacturing hub by 2030. So these are some of the aspects which need be considered. In addition, India's position as, or rather, India's trade potential is immensely benefited by India's geostrategic connectivity through initiatives like INSTC, which is International North-South Transport, linking Central Asia and Europe to India, and also IMEC, which is India, Middle East, Europe, with enhancing the access of India to the Gulf region. So these are a few of the aspects, I mean, which need be considered. That yes, India is a very favorable destination for the purpose of investment and business exploration and all. And of course, with India and Nigeria sharing strong historical and economic bond, it's of course a favorable destination for a cross-border investment in India. So when we discuss about it, let me also discuss the favorable investment regulatory regimes. Like if one wants to invest in India, there are two very modes of FDIs, foreign direct investment. It can be 100% certain sectors, like for example, agricultural sectors are there, manufacturing or automobile. It facilitates 100% investment. Then there are certain investment sectors which would require prior government approvals, and which are actually sensitive sectors where national interest and strategic considerations are paramount importance. For example, like defense sector or telecommunication sector, media, etc. So when in 100% FDI sectors, one only need to inform the RBI or the regulator that certain amount of investment, which is the desired one, has been actually put in the sector. That information is only required in the FDI, 100% FDI. And whereas where government approval is required, then there are certain approvals are required prior to making investment. So there are modalities and there are assistance provided for the purpose of attaining those approvals. It's not that it is very difficult or non-attainable. Certain compliances are there. Then these kinds of investment can be put in either in the form of a wholly owned subsidiary of a foreign company in India, or it can be by joining hands with an Indian partner in the form of a joint venture company. Or it can also be by opening of a licensing officer or branch officer, depending upon the investor's operational goals as to how they want to go ahead investing. Aside to this, there is also, one way of investing by making in foreign portfolio investments, which is also a very regulated sector. And it's by investing in Indian capital market. Rather, it's a quite regulated sector and very rigorous regulatory regime is there, ensuring that the investment is secured. So when we have talked about this, let me highlight once again that India is a favored destination, investment destination, seeing its rapid growth, having a largest global market, and its supportive policies with Indian government putting up ease of business doing, modalities in place, and then giving 100% FDI schemes and all PLI schemes, business favorable schemes of positioning the businesses in SEZ areas and all. So those are the tax holidays under the SEZ. I mean, if one wants to have its business positioned in SEZ, then first 5 years there is no tax, income tax, and then rest of the 5 years there are exempted taxes and all. And then there are the taxation issue with respect to country-wise. I mean, India follows standards, global standards, with respect to like base erosion and profit sharing. I mean, I'm sure Shubham is going to speak up more on that aspects. So these I could share with respect to India's status as a compelling destination for investment. Thank you.
We wondered at the amazing way that you have streamlined in all the way that there are advantages. But when we speak from a strictly regulatory perspective of setting up and just inviting an investor in, given the fact that there are different states within India, we do follow a quasi-federal structure. There are multiplicity and overlapping laws. There are licenses, multiple licenses, compliance requirements. Do you see that the regulatory complexity plays a hindrance in the investment of a foreigner? And if so, then what are the what would be a guiding to-do list, or what would be a guiding document check that an investor needs to take into account when before stepping or starting work here in India?
So I think even though the detailing has to be done by Shubham, I may just indicate that yes, you are right. There are certain overlapping laws, including with the state legislations and central legislations. Uh, so there are streamlinings. For example, if I may give an example of GST, goods and services tax. Earlier, there has been various taxation regimes within state government and then central government as well. So with the application of GST, it has been streamlined to the largest, to a major extent. And so far as these kinds of regulatory challenges that you say, or that you would highlight, I mean, these can be tackled. It's not that it is really challenging or it will be a hurdle to for setting up a business in India. There are modalities for compliances and all. You just need to comply. Compliance is the word uh, where you do your businesses in a compliant manner by following the law. Of course, there are professionals who assist in compliances of all the laws that are regulatory regimes and all. So by helping of the by with the help of the professionals who are there in the field, one enterprise, they get the assistance, all kinds of assistance with respect to compliances and all, including taxation regime or the sectoral regulatory regime, filing of obtaining of licenses, or you may say even the labor legislations, compliance of with respect to the labor laws and all. So they are all, I mean, or maybe in case of legal metrology, those are the legislations where one is required to comply with the required laws.
Right.
Enterprises may not be equipped immediately to comply with them, but then there are professional services available who would efficiently and cost effectively provide the assistance. So that
Thank
can
you.
be everything.
Thank you, Jyoti sir. Moving on to Shubham, to you, I would like to, from you, I think we would all like to understand that the world just came out of, and we are still struggling with COVID. So, healthcare and cross border, the lines have completely diminished. Now, India is sending healthcare products out. We are importing where we need to. Like I said, the lines have completely gone now in terms of understanding a border. In such a situation, specifically for a healthcare or a pharmacopoeia industry, if there are investors, how do we protect these investors, and whether our existing bilateral treaties, the BITs, or our double taxation avoidance agreements, are they enough? Do they have sufficient inbuilt mechanisms in them to protect a meaningful investor when we are talking about pharma sector and the healthcare sector specifically?
Thank you, Yashodhara, for that question. As you had stated before Jyoti sir gave this wonderful answer, as you had stated, India is Nigeria's largest trading partner in Asia, and nearly 200 Indian companies operate on Nigerian soil. These are mostly related to IT and manufacturing, and steadily now, even healthcare and pharma is also coming into picture. So the services that Indian companies or Indian entities are providing in Nigeria include the diagnostic chains, which are there, which have now started to show up all around Lagos. pharmaceutical majors setting up local production plants under Nigeria's API substitution plant. It's basically active pharmaceutical ingredient substitution plan, where India is supposed to provide these ingredients. And there are even telemedicine partners which link Indian doctors with Nigerian clinics. Success, however, is far from uniform. Healthcare is a high capital, high risk, high regulation, and high scrutiny sector. Investors often face delays in clinical approval, lack of legal protection for IP, which I am going to talk about a lot, non-transparent expropriation of licenses, and there are inconsistent tax treatment across various jurisdictions. Now coming back to the issue that you had touched upon, issue of double taxation avoidance. So the point here being that India and Nigeria, they have been trying to negotiate this among themselves, but we have not come to a firm agreement so far. But in sectors like healthcare, where there are multiple streams such as licensing, consultancy, dividends, supply contracts, DTAs are very important. And these obviously they provide advantages to both the home countries as well as the host country. Now, where India and Nigeria have negotiated a DTA, the negotiations are again still going on. It remains unsigned. There are interim provisions, and domestic tax relief laws do offer some protection, but not with the clarity or enforceability of a DTA. So, something like a JV related to pharma cannot come up because, again, there's not much clarity, and businesses don't want to put in money where they are unsure about the regulatory aspect. So right now, that there are a lot of limitation of the framework that exists. First is there is no coverage for indirect taxes like VAT or other regulatory fees. There are no investment protections or procedural rights for tax-related disputes. These are not designed to handle new models, cross-border e-health, medical technology, IP leasing, or digital clinical trial services. These agreements are old and they generally don't update that often, as is the case with a lot of regulatory regimes. So in short, DTAs are necessary, but they are far from sufficient, especially for a sector where value creation and IP is most important. Physical infrastructure anybody can create, but the real value lies in IP. So now I would want to talk about bilateral investment treaties. India and Nigeria, again, they are in discussions for a BIT, but currently there is a 2016 Indian model BIT that is the draft benchmark. But again, it's not been negotiated properly between the countries. So now there are some protections available. There are protection from unlawful expropriations. There are fair and equitable treatment mechanisms, non-discrimination, and most importantly, most favored nation clause. However, there are limitations of this framework. First, it adopts a narrow enterprise-based definition of investment, which again, most importantly, it excludes intellectual property and contractual arrangements, both which are very central to pharma industry. Second, it mandates exhausting local remedies for at least 5 years before international arbitration. I am sure which is daunting for most investors, given there are so many judicial delays. There are also public health carve-outs, which effectively allow host governments to regulate more freely in healthcare, even if investor rights are harmed. So again, the investors, they do not have a lot of incentive to, again, pour in money.
So when you say that there might not be... So sorry, please continue.
No, I'm so sorry. You can continue with the question.
So it was a very interesting turn. So when you said that because these two major agreements that usually protect investor interests, when they are still being negotiated, there and nobody would like to put their money where they are not sure of a regulatory landscape. We have already, with Jyoti, we have already understood that because of the multiplicity of laws already within India, the regulatory landscape is already a little bit going up and down. Within that, now we understand that there is a lack of a clear dialogue in the investment protecting clauses within the BIT or the DTA, mostly because they are still being negotiated. So when we said that IP leasing is much more important for pharma, is it not true that it also extends to our manufacturing units? So when we talk about the investor, a Nigerian investor coming to India, let's say energy has been well established, petroleum has been well established. How do we stand in terms of entry of foreign tech, in terms of entry of manufacturing firms? And how do we see a regulatory challenge that India is currently facing in the lack of a investor from these backgrounds of Nigeria? How do we counter that?
Uh, Again, Yashodhara, we we are, I believe, our jurisprudence with respect to both the countries, we are focusing more on just signing the treaty and not on restructuring as we should. So again, I have a few ideas as to how that can be done. First is we have to modernize everything. We
Right.
have to recognize non-physical assets like license, research contracts, and regulatory approvals as valid investment instruments. Uh, I don't know how the government can do that. They plan to do that, but they have to be uh, approved as valid assets for all the entities involved, more valid than they exist right now. There can be specific annexes for sectors like healthcare and life sciences to avoid public health carve-outs from becoming total exclusions. Uh, Again, we have seen this in pharmaceutical industry in India also, because there's so much government control that a lot of medicines are not just available in India because again there is price regulation here. Uh,
Right.
we, we can allow, but with checks, or this will give a lot involved. Second, we need to revamp and we need to finalize the DTA, which recognizes digital economy. It needs to cover email consultancies, cross-border digital pharma R&D contracts, and other intangible IP licensing income as well. We also need to harmonize definitions of permanent establishment that modern like medicine, for example, like Practo, where you can just call up a
Right.
doctor and they'll write you a prescription. You can within 2 clicks just pay off, and then the medicine will come there. Now it's a hybrid sort of a situation going on. Uh, Now, third and most important, this is my personal pet peeve. I want there to be a single window ecosystem everywhere. Just go on, log
Yes.
into one system, and you get all the licenses right then and there. You don't have to run pillar to pillar. So, and apart from this, once we have this, we also need a sort of joint committee of where both Indian and Nigerian governments are involved, so that a lot of disputes that come up, again with respect to regulatory authorities as well. Because if you are a foreigner and you are trying to liaise with the government in India, that can be difficult. So having a system like that where both the government's officials are involved and everything is transparent, it will make things easier, give comfort to investors, and again, it will be better for both the economics. Given how great India is when it comes to manufacturing of medicine, India is sometimes considered to be the capital of manufacturing vaccines in the world. So India has a lot of potential to serve the world essentially.
Right. So essentially, what we can understand is, apart from while we are constantly negotiating to get into fine tune the DTAA and the BITs, we can also work towards not only having specific MOUs intersay the various departments within India, but also those departmental MOUs with the Nigerian government, so as that even if the main agreements and the treaties are missing something out, the MOUs will show a joint cooperation between the parties, between the two countries, so that investments also go on, so that there are licenses which are at a one stop portal where we can apply for it, and also we can figure out investor protective methodology in terms of their taxation benefits, in terms of their export obligations and such. So while these are still in the discussion stages and the investor coming in, one thing that always scares an investor, and here I would defer to Mr. Jyoti for his expertise, is the adversarial situation or facing them in court, taking up arbitration, it becoming very lengthy. Now in India, when we are coming up with newer acts, the new AI, the DPDP Act is going to come in, the artificial intelligence has come in, the regulated competition bill 2025 is getting passed. So with the new changes that are coming in, how do we see the dispute resolution booming up or booming less within India as a whole? And how would that potentially ward off any investor or would not ward off any investor? How does that pan out?
Okay, that's interesting question. So there's two aspects. One is dispute resolution, and one you highlighted the digital part of it. I mean,
Yes.
of course, digitization, use of technology and particularly digital technology. I mean, it has a significant impact, and the impact is even more significant when it is driven by AI. So artificial intelligence, that is machine learning, and they are doing things for you. So technological advancement inevitably requires in place conforming regulations or regulatory regime. So, I mean, when we are talking about a dispute resolution, we need to understand what is the regulatory regime, right? So, and the trends with respect to these regimes, regulatory regimes, are to address the complex challenges posed by artificial intelligence, cybersecurity, as well as digital competition, because there are larger players, how to tackle them. So, I mean, and I must highlight one thing: when we talk about AI, artificial intelligence, then there is a lot of significance with respect to generative AI. So a regulatory regime has been thought of, which can then fix the liability or copyrightability of AI generated contents. And in that context, the regulation is being developed to clarify ownership rights or responsibilities for infringing outputs, or I mean, to tackle the issues surrounding them. Now that is one part. Then there is a digital competition bill, which is yet to, I mean, it's in the bill form. It is yet to see the confirmation, and it is still in discussion. So it's a draft only, and it seeks to prevent anti-competitive practices by large digital platforms, so as to ensure a level playing field for the startups and innovators. I mean, we have achieved this kind of fast growing economy by use of startups and innovators and all. So in order to have them a level playing field, it is important to balance between the larger players and these smaller players, or startups rather. We can't say them smaller players. Startup is an exact word, which holds the significance. And then we also have, I mean, a lot of emphasis with respect to cyber securities, given when the use of, I mean, technology in the payment solutions and all, money transfer solutions. So I mean, that security is also important, and with respect to data protection, that's why DPDP Act is there. Then there is a strong push to frame a policy with respect to AI, compute, and semiconductor infrastructure. So, and then there is another initiative of government to integrate the digital, I mean, the AI with digital public infrastructure. I mean, public using infrastructure facilities that has to be AI driven. So those are the initiatives. Now,
Right.
these are with respect to technology. I mean, technology or AI, or that you may say. But answering your second question, I mean, I'm just trying to confluence it. The dispute resolution, when we say, uh, in the context of Nigeria, what we look at it is largely infrastructure contracts or infrastructure engagements, largely. I mean, of
Right.
course, tech, pharma, other things are there. So with respect to these kinds of, I mean, if I sum up, so when it comes to infrastructure disputes, they are very high in value. They are sensitive. They have got public importance. There are a lot of political issues and national issues involved. So there has to be a lot of significance involved in those kinds of contract. I mean, enforceability of those kinds of contracts, or dispute resolution mechanism involved in that. So India and Nigeria both being signatory to the New York Convention, I mean, a global standard to have those dispute resolution processes aligned is of importance. Now here I must underline this, that recognition of award under the New York Convention, that is the significant aspect. So if there is an international foreign award, whether it is enforceable in Nigeria or whether there is a that foreign award is enforceable in India, that is of important import here. To that effect, I may highlight that the both the legislations of both the countries, they they have comprehensive statutory framework that mirrors international best practice. For example, in relation to uh, limited judicial intervention or limited judicial interference, party autonomy, and enforceability of foreign awards. These are the three important aspects. Now, in relation to infrastructure aspect in projects specific, parties need to have the liberty to choose neutral jurisdiction to avoid any kind of biasness or any kind of uh, inconvenient, or those kinds of inconvenient feelings between the parties. So neutral choice of neutral venue, seat of arbitration. There is a difference between seat and venue. Party autonomy. Party can drive mutually the procedurals and all, and opt for mutually acceptable governing law. That is also one of the important aspects with respect to infrastructure disputes. Then appoint arbitrators with technical expertise relevant to the project. So if there is a project and the arbitrator is not technically equipped, there are hurdles to make him understand the technical nuances of the project, which may then lead to not correct award, or it may hinder the award process and all. Then these things aligned in the arbitration agreement, or these things aligned in an statutory framework, helps in maintaining the neutrality, technical accuracy, and commercial confidence of the parties. Now, despite these in place, there are certain challenges as well. I must highlight that as well. So it could be procedural bottleneck in India. If I highlight with respect to Indian perspective, enforcement of foreign award can be or suffers procedural bottlenecks, like whether the award has been passed in a suitable manner so that there is an enforceability of the award. So before the foreign award is put up for enforcement, enforceability of that award is first decided. This is one procedural aspect. Then only it goes to enforcement. Then scope of public policy. The public policy, though in the context of foreign award, has been watered down a lot, but still there are a lot of room open up. And it was said by a judicial brain in some of the seminars that public policy is an unruly horse, difficult to control. I may not deny in the perspective of Nigeria as well, because each country have their own public laws, public sentiments and all, which are of importance, and they all then gain significance into public policy. So this is and that's why it is said as it is an unruly horse. You need to control it with all your might. And when I'm discussing about these things, let me before I discuss further, let me also highlight what could be the hurdles on the Nigerian perspective. So in Nigeria, enforcement against state-owned entities may face hurdles due to sovereign immunity claims, sovereign immunity clauses, right? Sovereign may claim immunity against them. In India, that immunity is no more there. There is a judgment of Delhi High Court which says that sovereign immunity you can't claim when you are entering into a contract. You are a private party. You have to be treated as a private party in a contractual terms. No sovereign immunity, but that is there in Nigerian regime. Then regulatory constraints such as foreign exchange controls in relation to award or in relation to transaction which is in foreign currency. So we do have FEMA, but there are stricter norms in Nigeria. So these can be some of the hurdles in enforcement of foreign awards. And then achieving the standards of New York Convention. I may be missing out if I don't discuss very slightly two judgments in the context of Nigerian context. So first judgment is PESL Wind Solutions Private Limited versus GE Power Conversion India Private Limited. It reached to Supreme Court, and it has relation to Nigeria only in relation to the transaction of business which was there in Nigeria. Both parties were Indian. They had a fancy to choose a foreign jurisdiction foreign seat of arbitration in Zurich.
Right.
Now, and then they very conveniently choose and they mutually decided to have a venue in Mumbai, a city of India. So award was passed in favor of one party. The unsuccessful party tried to challenge or try to resist the enforcement by saying that, see, both in two Indian parties cannot choose a foreign land, foreign jurisdiction, and then have a foreign award. That was negated by Supreme Court by considering UNCITRAL law, New York Convention, and saying that no, standards are there. You have to apply principles of those New York Convention only to challenge the award or assist the enforceability. If they are missing and there is no bar, that two Indian people can choose a foreign venue to produce a foreign award. Right. So that was found to be enforceable. And there is another judgment of Nigeria versus P&ID. So it was, though no Indian party was involved there, but then it was a judgment where Process and Industrial Development Limited, which is P&ID, and Nigerian government, Ministry of Petroleum Resources, they entered into a contract for gas supply. Dispute arose. P&ID filed an arbitration, and that contract was having a seat of arbitration in England. So arbitration was conducted in England. Unfortunately, Nigerian government could not resist it or could not produce their defense properly during the arbitration. However, when the award was passed of around 6.6 billion USD, Nigerian government challenged it before the English court. And then English court found out, and it actually adjudged that arbitrators were at fault, arbitral tribunal was at fault by not giving proper opportunity of presenting the case or proper opportunity of defense to the Nigerian government, and the Nigerian government was successful in setting it aside. So this was possible because of the applicability of international standards of New York Convention imbibed by the English court. So to sum it up, I mean, if we have a global standard which has objective values, objective standards laid down, if you follow that, there should be satisfactory dispute resolution.
Right.
I mean, helpful to all the parties involved, stakeholders.
So when we talk about global standards, like you rightly pointed out, the New York Convention, we have the London one, we also have the SEAC rule. So these are the perfect venues and the perfect seats of arbitration that we can go for when we are tackling international and commercial arbitration.
Right.
So now that we have an understanding, and here I would like a little bit of Shubham's expertise here, and with that I would move on to our friends. We understand that of late India has come up with a lot of governmental initiatives with the National Infrastructure Pipeline, Make in India in 2014, the free trade agreements that we are constantly signing, the Startup India schemes, Nidhi initiative, Startup India investor content. So do you think that with these various government initiatives, what kind of regulatory advantage do you think India can give as a conducive and as a legally secure destination for our investment opportunities for our Nigerian investors specifically?
Thank you, Yashodhara, for your question. And I must say, it's always such a pleasure to listen to Sir talk about dispute resolution. I can listen to him
The
for hours.
passion is the passion cannot. There is no word. It's indescribable.
Yes, it's almost contagious, so to speak.
It is.
Now, okay. Now coming back to the question at hand. Again, India in the last decade has globalized quite significantly when it comes to investments coming in or investments going out. So India has now maintains a very transparent and liberalized foreign investment policy, which we call as FDI. So there are most sectors today, as it stands. In 2020, this was not the case. That most sectors today allow 100% FDI through automatic route, and for most of the countries, it's allowed, including manufacturing sector, fintech sector, infrastructure, and even digital media. So 100% FDI is allowed there. There are some strategic sectors like defense and insurance that have seen only progressive liberalization. For example, insurance sector FDI cap was recently raised to 100%, and now 100% FDI is allowed there. So the government it still continues to review and to reduce barriers through expert committees and ongoing liberalization. As a matter of fact, I would just like to uh, hone on the fact that we also sometimes advise with respect to these expert committees and consultation. Yashodhara is an expert in the field. Uh, Now the government is also taking some other steps to make sure that regulatory lapses are not criminalized. That means only a penalty is raised. The government has now decriminalized a lot of provisions to reduce penal liabilities. Tens of thousands of compliances have also been cut down across sectors if I talk about everything at once. And there are further reforms which are happening for ease of doing business. Now, again, as I had stated before, that one of my pet peeves is not having a single window clearance system. Now, the government has started doing this. There is a national single window system scheme that allows businesses and investors to multiply for a lot of licenses at one place. It covers central government, state government, and sometimes even municipal or even gram panchayats, which are basically the village administrative regions in India. Now, India again, we as lawyers, we pride in stating the fact that India has an independent judiciary that has a lot of specialized commercial courts and tribunals that are now expediting these dispute resolution. Apart from going to judicial bodies, there are also regulatory bodies like the Reserve Bank of India, SEBI, which basically regulates the capital markets of India, or IRDAI, which regulates the insurance markets of India. So a lot of disputes or a lot of regulatory lapses are now handled by them, therefore reducing burden on courts and ensuring that all of these lapses are very expeditiously taken care of. There are also competitive tax and fiscal incentives that Indian government gives. For example, exporters can benefit from schemes such as the remission of duties and taxes on exported products, EPCG, which is basically export promotion capital goods, and other initiatives as well. These initiatives, if you couple them with transparent GST compliances, they again create a fiscal certainty for investors, which is what they like. If the compliances are a lot, not a problem. But if they do not know what to comply with, that's a problem for them. Now, again, there is one more aspect that I would like to touch upon. There is a very important thing that an investor looks for, which is for its own protection and ensuring it gets equal treatment before all the bodies. So again, in India now guarantees national treatment and non-discriminatory access to foreign investors post establishments. And there are also a lot of transactions where RBI has also made sure that equal treatment is met. This can be ensured simply by being transparent, the entire process being public, and the officials responsible being made answerable to the public. So I would just like to summarize by saying what we have is comprehensive regulatory reforms. We have a very investor-friendly FDI policy. We have institutional robustness, and we have a lot of fiscal initiative that make it a quite conducive and legally secure destination, India, for international investors and businesses. Uh, Back to you, Yashodhara.
Thank you so much, Shubham, and thank you, Jyoti sir, for your absolute insight into the regulatory framework, the judicial framework, how it pans out. My key take notes from this entire first part of the session with India and its opening up to Nigerian investor. I am still a little bit skeptical given the country that where we are. We do see that there, because of, and I would harp back on the fact that there is a regulatory complexity because we have so many states. There are, every state has its own laws when it comes to its licensing, when it comes to its labor reforms, when it comes to, most importantly, and we cannot impress upon this any further, the land acquisition. So, given the regulatory challenges and the clearances that we constantly see, we would see where an investor may feel a little bit edgy before they actually jump and go ahead with it. With that, I also understand that we are a huge country. There are huge issues of judicial delays. There are tax disputes constantly because of the multiple interpretations, even with EPCGs and several other gateways in terms of the export liability reductions, import liability, the lessening of an import liability. There may be several red tapeism that is promulgated with, of course, the infrastructural gaps that we do see in India. But that being said, the wondrous part of it was also is that you can conduct due diligence because of the utilization of AI. Now we have seen that land records dating back as 1990, 1998, they have now been streamlined. You can approach them online. You do not have to go to a specific sub registrar's office to take the documentations out. You have them online. If you can figure out the right entry route, which would be the best way for you to start, whether through a licensing office, whether through as a portfolio investor, whether as a wholly owned subsidiary, those are some of the things. India has several SEZs, which are the special economic zones, which give you several benefits. So from the taxation perspective, from customs perspective, and thereafter, because of India now with our current government looking more to make India investor friendly, investor compliant, we have come up with Invest India, Startup India, Make in India desk. All these desks have government, these are government agencies with their agents who are constantly helping to make the compliances easier, to give them a proper understanding of the policy. And apart from that, something that always helps, that you have to keep on monitoring a legal and a regulatory market of a particular country, because that is brittled with politics, that is brittled with their constant regulations, their fines. And like Shubham said, one thing that India is wonderfully going ahead with is decriminalizing several of the shortfalls and only attaching just a penalty as a stepping stone. So, with that, I think I would love to move on to our friends and introduce Mr. Adeola, Miss Ayoola, and Mrs. Deborah here. And we are so grateful that we could have them join with us on this webinar and discuss with them the regulatory framework for doing the business in Nigeria. With the landscape, we understand that it is a huge and beautiful country. It is the gateway into the Western African sector, and they have a significant employee with over 70% of the employee as part of their workforce. And the country has been doing wonderful work and is an investor. How do I say? An investor landmine when it comes to agriculture, technology, and fintech, and specifically in their real estate, because so much of Nigeria is still unchecked for. There is so much land where there is a booming manufacturing and booming real estate development opportunity. And because of the housing deficit, which we had seen West Africa struggle through, real estate is booming currently, and that gives you the incentive for investment and the necessary support. And like we said, that the Indian diaspora of a huge, significant amount of 50,000 being already present in Nigeria, this works as a wonderful gateway, with furthermore helped by the, as we understand, there are several tax holiday benefits that are also available. So with that, I would request Ms. Ayoola to walk us and help us understand the restrictions that may be, if any, on the automated data processing. And for in a world of artificial intelligence, how do we see the AI developers design compliance systems without...
Can you please see what's happening?
I'm sorry. Has my Am I audible now to the speakers?
Yes, Yashodhara. You are
I'm so sorry, but if there was a glitch, I apologize for the same. I was just posing my question to Ayoola, and we wanted to understand that what are the different restrictions on an automated data processing, or how should an AI developers, they should design their systems to be compliant without undermining the utility of a machine learning model, which is reliant on so many huge data sets. Because AI today, we understand, and these data sets are important in addressing the real estate issue, the energy barriers, the agricultural barriers, which are the major investment prone areas within Nigeria. Ayoola, on to you, please.
Okay. Thank you very much, Yashodhara, for that question. And when you were doing the introduction about Nigeria key investment sectors, you did mention about agriculture. You also spoke about technology, which is what I'm focusing on right now. So the technology sector in Nigeria, in fact, Nigeria has been the landmark for Africa when it comes to the technology sector, because Nigeria has attracted a lot of global attention and interest when it comes to the technology and the fintech sector. And as a result of that, the Nigerian government has made it a point of a mandatory. They have decided to ensure that the fintech and technology sector is well regulated, and then it meets up with the global standard everywhere. And as a result of that, coupled with the emerging trend in some key areas of fintech and technology sector as a whole, for instance, we have the data protection area, we have the artificial intelligence and machine learning, we also have the cyber security area when it comes to the technology sector in Nigeria. And then in order to have a regulatory legislation that will guide the activities in the tech sector in Nigeria, the Nigerian government, there has been some emerging trend in the tech regulations in Nigeria. And recently in 2023, the Nigerian government enacted the Nigerian Data Protection Act, which is the principal act that is regulating the data protection in Nigeria. And then also, when it comes to the artificial intelligence regulation, as I speak, actually, there is no uniform legislation for artificial intelligence in Nigeria. But that notwithstanding, we have some regulations that are guiding the that in order to protect the interest of users, and also to ensure that developers of these artificial intelligence are in compliance with the laws and regulations of the country, in order to avoid breaches and violations of the Nigerian regulations. So there are some regulations, even though there is no specific area regulation in Nigeria, we have some regulations that manage and regulate the activities of artificial intelligence adoption in the country. And one major one is the Nigerian Data Protection Act of 2023, which is the Nigeria's principal act when it comes to data protection in Nigeria. So with regards to your question that has to do with automated decision making through AI, the Nigerian Data Protection did specifically provide, we have that in section 37 of the Act, that the Act restricts automatic decision making when it comes to the rights of data subjects, that is the Nigerian data subjects. So the Act does not permit automated decision making or data processing when it will affect the legal obligation, the legal rights, the fundamental freedom and interest of the concerned data subject. So there has to be compliance with some set down guidelines before the AI, so to ensure that the AI developers are not in violation of any part of the Nigerian Data Protection Act. And although there are exceptions to these restrictions, we have in a situation whereby the data subject did give free consent to such processing, then the restriction will not apply. Or if it is for the performance of a contract between the data controller and the data subject or the affected individual, then the restriction will also not apply. Or if it is for the fulfillment of a legal requirement or obligation. For instance, now the Nigeria Data Protection Act did establish the NDPC, that is the Nigerian Data Protection Commission, that is saddled with the responsibility of regulating and implementing the provision of the NDPA. So if such automated data processing is as a result of the data processor or controller performing their legal requirements or obligation under the law, then the restriction on automated processing will not apply. But in a situation whereby the processing does not fall under any of these exceptions that I've mentioned, then for the AI developers to be fully compliant, or in order for them to not to violate any of the provision of the NDPA, or strictly the automated processing restriction, in order not to violate that particular provision of the Act, then the developer must ensure that they put in place some measures, technical measures, organizational measures, to ensure that they are in full compliance of the law. So I'll be giving instances. For instance, we have that the first one actually is that before you can actually say that you want to comply with the provision of the law, the first thing you need to ask yourself is, what is the provision of the law? Do I even understand what the provision is talking about, or the intention behind that provision? So understanding the provision and the intention behind the provision is one key thing that the developer must ensure that they address. And for this restriction, data sub
I think Ayoola, we lost you in between.
Okay. Can you hear me? Can you hear
Yes,
me now?
yes,
Okay.
yes.
I'm sorry for that glitch. Yeah. Okay, so I was saying that for the AI developers to ensure that they are in full compliance of the law, particularly the data protection law, the Nigerian Data Protection Act of 2023, with regards to that restriction on automated data processing, the AI developer must ensure that they put in place the organizational measures and technical measures to ensure compliance. And before they can do that, they need to first understand the provision of the law and then the intention behind it. And when it comes to that particular provision, the intention is actually to protect the interest and fundamental rights and interests of the data subjects. And then if that understanding is there, then it will be easier for the developers to be fully compliant. And when we talk about putting in place technical and organizational measures, the Act, in fact, went ahead to provide that the developer or the data controller, in this case now, must ensure that while they are developing the AI, they must ensure that the constant, if it is necessary in a situation whereby they will be dealing with, of course, we know that artificial intelligence deals with vast amounts of data that is being used for training and then for operations. So as a result of that, they must ensure that the data subjects, in this case now, has the right to either challenge the decision-making process. Like if the automated processing is being adopted, then there must be a mechanism that allows the data subject to contest or challenge the decision of the AI at the end of the day. And also there must be a provision, there must be a measure that allows the data subject to have an input in the process. They must be able to share their own view about the process and not just shut them out of the whole process entirely. because AI deals, like I said earlier, deals with vast amounts of data, and when it has to do with the creation or development of a particular AI that deals with sensitive data of data subjects, then another thing that can be put in place or another thing that can be carried out is to conduct what we call a data protection impact assessment. The Nigerian Data Protection Act did make provision for that, and the DPIA, that is Data Protection Impact Assessment, is recommended when it comes to processing of data that involves high risk. For instance, when it has to do with sensitive personal data of data subjects, such as health record, such as religious belief or probably political connection of the data subject, or the health record of the data subject, or let's say, for instance, data such as genotype or blood group. These are sensitive personal data. And then if the creation of the AI will involve processing of such data, then before it is being launched at the development stage, it is mandatory actually that a DPIA is conducted on that AI to see the potential impact it will have on the data subjects whose data are being used to train and develop the AI. So those are some of the measures that should be put in place. Another thing is that when it comes to automated decision making or automated data processing, it shouldn't be left solely to the discretion or the decision of the AI. There should be some elements of human intervention or oversight. For instance, now let's give an example of employment process. For instance, advert is being sent out, there are applicants, and then there is an AI machine that is being automated to filter the applications of applicants. And then if in such an instance, because you are dealing, of course, such a machine is dealing with vast data of the applicants, and then it is unacceptable by the provision of the Nigerian Data Protection Act to leave such decision-making process solely to the discretion or the algorithm of the AI machine. So probably towards the end of the whole process or during the whole process, there must be a measure that is being put in place that allows human intervention, so that there will be prevention of discrimination, or there won't be bias in the process at the end of the day. Because like I said when I started speaking on this topic, that there should be a measure that allows the data subjects to challenge the decision at the end of the day. So if there is no human intervention or oversight in the process, then such it could amount to a violation of the data subject rights to challenge, or the data subject rights to even have their own view about the process, that okay, this is how the whole thing went and all of that. So there should be that the data controller or the AI developer should ensure that such opportunities are available to the data subjects. And then yeah, and another thing I would like to make mention of is that during the whole process, automated process and everything, there should also be proper documentation and transparency, because where there is lack of proper documentation, in fact, it even affects the whole process as a whole, because at the end of the day, because the Nigerian Data Protection Act made it mandatory for data processors and controllers to have annual audits their activities to submit the annual audit report. So in a situation whereby there is no proper documentation during this process, then it will be very difficult to comply with the provision of the Act. So in fact, Section 37 is just one out of many of the provisions of the Act that is very mandatory for data controllers and data processors to comply with. And some of these provisions are actually they are connected with each other. So compliance with one will also lead to compliance with another provision of the Act. Yes. So I think that is the major safeguards or measures that can be put in place by data processors or data controllers when it comes to automated data processing in order to prevent a violation of the provision of that Section 37 of the Act.
No, this is wonderful to know that even with the AI being on everybody's mindset, that the NDPA does put a restriction and there is a human intervention, and this is wonderful to know. And from that, we would like to move on to Mr. Adeola, and we would love to understand a little bit on the anti-money laundering obligations which are currently in place for non-financial businesses. So given these obligations and the CFT obligations that the non-financial businesses have to follow, what we would like to hear you on what kind of institutional infrastructure or compliance architecture do you think that a foreign investor has to establish at the very get-go, at the point of a market entry, when they're thinking of Nigeria as an investing opportunity for themselves, in order to avoid any kind of bureaucratic red tapeism or regulatory penalties?
Okay, many thanks for calling me. Yes, before I get to the anti-money laundering question, let me just say that cross-border investments are never just about capital. Because I've had my colleagues from Hammurabi and Solomon, they've really spoken a lot. And they are just about the meeting the regulatory expectations of more than one jurisdiction at the same time. So for companies seeking to cut across various jurisdictions, so this often means navigating differences in foreign investment laws, anti-money laundering obligations, and beneficial ownership requirements. So my response, we aim to unpack those layers and offer clarity where compliance trends tends to get complicated. Now, to the FDI frameworks in Nigeria, we all know that FDI means foreign direct investments. The law enforced in Nigeria include what we call Nigeria Investment Promotion Act. We have Foreign Exchange Monitoring and Miscellaneous Provision Act. We have Companies and Allied Matter Acts, popularly called KAMA in Nigeria. With these and other regulations, collectively, these laws provide the foundation for foreign investors to legally establish, operate, and exit business ventures in Nigeria. Let me also state clearly that FDI broadly allows across most sectors. The law guarantees non-discriminatory treatment in Nigeria, protection against expropriation, and the transferability of capital, profits, and dividends, provided the investors comply with applicable regulatory procedures. But let me quickly state the key consideration for foreign investors who are targeting Nigeria. The first one is incorporation. For those who want to do business in Nigeria, is very key to register your local entity in Nigeria. And Nigeria also offered free zone business opportunities. So one can as well register a free zone business in Nigeria. Another one that is very important, a very germane key consideration for foreign investors is what we call capital importations. So companies with foreign participations are required to import their business capital through authorized channels and obtain a certificate of capital importation. And another key consideration is the minimum share capital. Generally, we can say with 100 million naira, share capital is what is allowed in Nigeria. But I must also state that some other sectors that are regulated by different regulatory bodies, the regulatory compliance may require that you have more than 100 million share capital. And it's also very important to state, because these are the questions we usually answer when foreign investors are coming to Nigeria, whether they can own their company fully is allowed in Nigeria for a foreign investor, or foreign investors to own their company fully in Nigeria, or also partially, that is by having a partner in Nigeria. Then the regulatory approval is the next, which includes business permits. It's very mandatory for those foreign investors coming to do business in Nigeria. Expatriate quota, even employing foreign nationals. Nigeria Investment Promotion Commission, NIPC registration is also very key. The local content requirements, while I mentioned that is possible, in fact, the Nigerian allows foreigner to own their business fully, but there are some local content requirements in some sectors. For example, oil and gas, aviation, for example, requires that local content requirements is 51%, media, and so on and so forth. Then I also mentioned obtain sector-specific licenses. Apart from registering your company, it depends then on the sector that the foreign investors is targeting. You must also get licenses. For example, if you want to operate in the fintech banking sector in Nigeria, CBN licenses are required. The same way, if one is also targeting telecommunication, NCC is required. Then I will also mention due diligence. Conducting thorough due diligence on potential partners and the local market is crucial for mitigating risk. Now I come to anti-money laundering compliance, as you've actually asked. So beyond entry and ownership rules, foreign investors must also navigate anti-money laundering and counter-terrorism financing obligations that arise during capital inflow, incorporation, and day-to-day operations. So these obligations are not limited to financial institutions alone, because people do normally ask us about this, but also apply to companies receiving foreign direct investment, especially in regulated or high-risk sector. So Nigeria requires compliance with Know Your Customer standards, customer due diligence, and transaction reporting rules, making anti-money laundering compliance a critical layer of cross-border investment regulation. In Nigeria, we have some anti-money laundering AML legal framework. We have Money Laundering Prevention and Prohibition Act of 2022. We have CBN Anti-Money Laundering and CFT Regulation of 2022. We have Terrorism Prevention Act 2022. So these laws impose robust compliance obligations and on financial institutions and designated non-financial businesses and professionals. So entities are required in Nigeria to implement Know Your Customer procedures at onboarding and throughout the customer relationship. So this includes identity verifications, risk profiling, and ongoing monitoring. So in addition, companies doing business in Nigeria must conduct what we call customer due diligence, identify politically exposed persons, screen against sanction lists, and carry out enhanced due diligence for high-risk accounts. Now, under this anti-money laundering, we also have supervisory and enforcement bodies in Nigeria. They include EFCC, Economic and Financial Crimes Commission. We have Nigerian Financial Intelligence Units. We also have Central Bank of Nigeria. We have a Special Control Unit Against Money Laundering of EFCC. So Nigeria's framework emphasizes strict timelines, currency-based threshold, and immediate reporting duties, especially important when processing foreign capital inflows on that foreign direct investment regime. So the mandatory reports in Nigeria include suspicion transaction reports, cash-based transaction reports, currency transaction reports, politically exposed persons reports, record keeping for a minimum of post 5 years transaction. One other thing that I also need to add is the beneficial ownership disclosure under the Nigerian law. Beneficial ownership refers to the natural person who ultimately own or control a company. Even if their names do not appear in the formal share register. In Nigeria, the obligation to identify and disclose such person is set out in Section 119 of Companies and Allied Matter Act, and further detailed in Persons with Significant Control Regulation 2022. So all companies, including public ones, are required to take reasonable steps to identify persons with significant control. A person qualified if they hold at least 5% of shares of voting rights and have the power to appoint or remove a majority of directors, or exercise significant influence or control over the company or a trust that hold such interest. So once a person qualifies as a person of significant control, they are expected to notify the company within 7 days. The company in turn must also notify the Corporate Affairs Commission within 1 month and update its register of members and disclose the information in its annual return. And the commissioner maintains a central public with significant control register based on this data. I know some of my friends have really talked about regulatory harmonization. That's just what I want to mention in passing. For Nigeria, regulatory harmonization in this context does not require uniform laws or the wholesale adoption of another country's model. Rather, it involves identifying core areas such as beneficial ownership, disclosure threshold, anti-money laundering timelines, and sectoral approval procedures, where standardization or mutual recognition could reduce what I call friction. For instance, Nigeria applies a 5% threshold for disclosing person with significant control, while India applies a 10% threshold for identified significant beneficial owners. So while all these differences reflect local policy consideration, they create practical difficulties for companies operating across both jurisdictions. So establishing a shared understanding or minimum standard will make compliance less burdensome without undermining domestic regulatory objectives. And then more broadly, harmonizing key element of investment and compliance framework will also significantly improve the ease of doing business in both countries. So it will allow capital to flow more freely by removing duplicative or conflicting requirements. And it will also provide greater certainty to investors who often face ambiguity in cross-border transactions. So such harmonization will not only strengthen the credibility of regulatory institutions in the two countries mentioned, but also position this country as more competitive and accessible destination for foreign direct investments. Finally, I would just say, as global investment becomes more interconnected, countries like Nigeria and India must continue refining their regulatory frameworks. While both countries have made progress, there's room for greater alignment in key areas such as ownership disclosure, anti-money laundering compliance, and investment approvals. So a more harmonized approach will ease capital flow, reduce compliance with uncertainty, and strengthen investor confidence across border. Thank you very much.
Thank you. Thank you, Adeola. That was wonderful to know. And yes, we were absolutely right with we have our beneficial ownership and our disclosure of a significant beneficial ownership and the demarcation thereof. And that goes a long way in protecting an investor. And that is something that an investor should definitely look out for when they're coming into an investing. When I would like to move on to Deborah and understand from her that when we talk about investments, and that is interestingly also a very somebody in our viewers have also posed this question, that with long project durations and the fluctuating regulations, multi-jurisdictional legal systems, how can two parties they foolproof the dispute resolution clauses when there are constantly changing political theologies, the policies are changing, there are unforeseen geopolitical shifts. How do we address this?
Okay, thank you very much, Yashodhara. Just like you have mentioned, due to long duration of cross-border infrastructure contracts, These projects commonly experience a lot of conflicts arising either from breach of contracts, either from evolving regulations and geopolitical uncertainties or sudden market changes. So there is need to put in place clauses that will protect the interests of the parties. That is why it is very essential to future-proof dispute resolution clauses in long-term contracts, like pipeline, telecommunication, technology, and all that. So there are certain strategies which parties, stakeholders are expected to put in place in such contracts. We have number one, there should be flexible disputes resolution mechanisms. Parties should include multi-tier clauses, like there should be mandatory negotiation. This can be done between the senior executives of each parties. And all they should be set, there's a particular time limit should be set. Parties should put in clauses like, okay, parties should negotiate in case there's any disputes within 30 days. Then if this fails, they should refer to mediation. If mediation fails, they can either put it at 60 days, 100 days, what have you, then they can refer to arbitration. And then there should be adaptive governing law. That is, as a fallback, if all this fails, there should be neutral and stable governing law. Then there should be neutral jurisdiction and institutions. Just like Mr. Chaudhary has mentioned earlier, the seats of arbitration should be neutral. They should choose seats of arbitration with strong enforcement treaties. Then they should appoint arbitrators that are not biased, because this will help to mitigate risk from geopolitical tensions. And then also there should be backup institutions. Like in Nigeria here, we have the Lagos Court of International Arbitration, we have the ICC, we have the Singapore International Court of Arbitration, we have the Hong Kong International Court of Arbitration, in case primary institutions become accessible. It is very important to choose a very stable and neutral seat of arbitration, because a politically stable and arbitration-friendly jurisdiction will reduce the risk of local upheaval influencing such proceedings. And then they should also avoid seats in jurisdiction with high political volatility, seats that have weak rule of law or that has recent regulatory turbulence. And also the third thing is that they should include geopolitical risk triggers. That is, by defining a geopolitical shift, where there is war, where there is sanction, this should be triggers for renegotiation, whereby the parties will have to go back to the board and then redraft whatever it is they are talking about. Then also there should be enforcement safeguards, like asset mapping. This will ensure that counterparts can be able to enforce such arbitration in jurisdiction whereby those parties have multiple assets. If there are multiple assets, it will be very easy to be able to, for that kind of award that is gotten at arbitration, to be able to be enforced. If you have, if parties have properties in that jurisdiction, it will make it very easy to enforce such arbitration award. Then there should be regulatory resilience. That is, compliance buffers. It requires parties to proactively monitor regulatory changes and then adjust their dispute resolution processes accordingly. Then also there should be sanction protocols. This will help in jurisdiction. They should exclude jurisdiction that are subject to sanctions. And then also, number 6, there should be technology and transparency. Parties should embrace virtual hearings, e-filing. This would in a way limit dependence on physical, going to physical locations which are vulnerable to geopolitical disruptions. And then there should be a blockchain for secure evidence. They should ensure that evidence, contract agreements are tamper-proof in a way that they will store the contract and communication, ensuring that there is continuity. And then there should be periodic review of clauses. Parties and stakeholders should ensure that they put in clauses like, oh, in 5 years, this agreement is subject to review. Just like I've said earlier, that they are long-term duration contracts. We have like installation of pipelines. It could take 10, 15 years. So parties have to include clauses that we give room for periodic reviews. It will not be too rigid. There should be a place where party can review. And then there should be a blockchain for secure evidence. And then there should be expert committees. In respect of, there are some particular contracts where you need experts like engineers when it has to do with construction. Experts are expected to be a part of the arbitration team. You cannot bring an engineer to come and sit on something that has to do with accounting. You know, it's not going to be good. But when you have people that are in their field, maybe there is a valuation dispute or construction, there are construction issues, which the person sitting as an arbitrator in that instance will be able to, due to experience or being in that field, he will be able to really speak and adjudicate on such issues before him. And then all these are also works of lawyers, legal practitioners, and stakeholders are expected at all times to include such clauses in every agreement before them. Because just like we have said earlier, cross-border infrastructure contracts are long-term, and there is no way, there is no how there would be disputes, because there's difference in geopolitical, there are geopolitical differences, the laws are not the same. So while they may appear complex, they can be effectively managed and often prevented through the right legal frameworks, strategic planning, and dispute resolution mechanism. So legal professionals and stakeholders must recognize this dual nature of cross-border disputes. They should balance the risk with potential reward, and they should develop strategies that are as expansive and adaptable as the global landscape they navigate. So thank you very much.
Thank you. Thank you. Wonderful. That was, I think my key takeaway was how wonderfully you said that for evidence protection, the use of blockchains. And that is something that we have been starting, but more so from a forensic investigation. But that shouldn't mean that the forensic investigation in terms of a company's financials should not be taking each document, putting them in a code of blockchain. That is how exactly it should be, to ensure the immunity, the longevity, as well as the protection and non-tampering. And these are some things that should be open for law enforcement, for investors to know that is how it will get protected. Even if you are in dispute resolution, that is how it will get protected. Even if you are having a conversational dialogue which is not adversarial, which does not need code, which does not need your institutional arbitrations, everything. And that is wonderful, and that would be one of my personal key takeaways in this entire context. Thank you so much. And I'm personally very grateful to Adeola, Deborah, and Ayoola, and such an engaging session that we had. Not to mention the entire landscape of dispute resolution, the wondrous milestones that India is taking in AI and digital protection, and the Make in India initiatives that Shubham and Jyoti completely navigated us through today.
So, Yashodhara, there is a question, I think, regarding the
I
sector.
believe, yes, there was a question, and that question, I think Deborah answered a little bit. So the question, I believe, panned more that how do we make it investor friendly when there are constant policy changes in both countries, given the geopolitical shifts that we see there? So when there is a regime today, there is great initiatives. What if the next governmental regime that comes up, there is not the continuation of the same policies? So I believe one of our questions it was more of a statement that there is one of our fears, that the uncertainty that usually stems from the policy inconsistencies. And coming to, we also have a follow-up question, that what sector of industry offer the most promising opportunity for investments between India and Nigeria? Would any of the speaker would like to take this on?
Energy, of course, is one. I mean, Shubham has talked about it something.
Yes.
Okay.
Energy.
I also have something to add, if I have the permission of all the panel members. I believe where India actually shines is service industry, basically relating to IT. Last I checked, India is expected to cross around $300 billion with respect to the total business done in IT sector. And Nigeria, last again, I had checked, it was around 1 billion or so VC investment. So there is a lot of gulf between the investment happening in India and Nigeria. That means there is a huge opportunity that can that can be there. India and Nigeria can both help each other in the IT sector. And again, the other sector would obviously be energy and renewable energy as well, so to speak.
So we
For
may
me,
answer.
I also think is okay.
Yes, please, Deborah, please go ahead.
For me, I also think is pharmaceutical. I think
Pharmaceutical, yes.
yes. Thank
Okay.
you.
Wonderful. Question to
for me,
Adeola would be, so there is one particular question that has been raised because of the significant beneficial ownership that we were talking about. So when you said that Nigeria defines a significant interest at 5% threshold, while India continues to do it at 10%, and given that Shubham also started that the bilateral investment treaties are still being negotiated. So the question is that is it possible that the bilateral agreement between these two countries address this specific issue and a reconciliation could be reached? And what would be an acceptable threshold which will protect the investors on both sides of the coin?
yeah, like I've already mentioned, this does not actually mean to undermine the regulatory policy of the two countries. But we have a situation whereby when we are having different requirements in a situation where investors from one country wants to move to another one, at times it poses a lot of difficulty or challenges for investors who are interested, because some investors who already have their parent country in a particular country, for example, like China, may not want to change these people with significant control in another country. I just mentioned if it's also possible for us to have an omnibus provision that will also take care of the interest of whoever is coming from one country to another without really affecting what's the internal policy and regulation is all about. Then for the question on what particular sector?
Yes.
Well, I know my colleague mentioned pharmaceutical because because a lot of people she's been attending to in that regard are from the pharmaceutical sector. But the honest truth is that all sector has its opportunities, risk, deliverables, and challenges. So it depends on what the investors is actually looking at, making sure that necessary due diligence is done before venturing into such a sector. That's what
We have one
matters.
final question, which is that, and this is to both sides. So are there any restrictions or challenges that are related to repatriating profits or dividends in a business transaction between these two countries? So Shubham or Adeola or Sir, whoever would like to take this question forward.
Yes, from Nigeria, we've had a lot of people having issues to repatriate either their profit or capital, but most of them, to be very honest with you, did not actually comply with the requirement in the first place. I made mention of having to, there are channels upon which you can bring in your capital into Nigeria. If this is not properly followed, then taking your capital back, including investment and profits, may be a challenge. But it's always very good when an investor is coming to a country to get a known expert in this thematic area to actually give them the guidelines and properly advise them on how to bring in their capital so that repatriation will not be a challenge at the end of the day.
Wonderful. Wonderful. Thank you so much. This was a wonderful session, and we learned, I think we engaged quite a lot, and we learned so much about the landscapes of both the countries. Any parting statements from Jyoti or Shubham or Deborah? Anything that you would like to say?
I would acknowledge, it was really a very engaging discussion and very relevant, of course, and very timely as well. And I would thank Mr. Adeola to join hands with us in organizing this so that our clients of both sides, they get benefited with this. And and they may, if any kind of issues they may get, or if any kind of even advices or any kind of questions they may have. I mean, they may come to us. Even on this webinar itself, when it is ongoing, questions may be put up across this, and even though we may not have time right now to answer them, we may give answers on emails or. So I will once again I will thank from the bottom of my heart to Mr. Adeola, Ms. Deborah, and then Ayoola for participating. Thank you so much.
Thank you, everyone.
Many thanks for having us too. And please feel free to be in touch with us if you need any assistance, legal support from Nigeria.
Absolutely. We look forward to this. We look forward to a collaborative initiative that we can embark on.
Thank you.
Wonderful. Thank you. Thank you, everyone. Thank you.
Thank you very much.